Hello, my name's Anthony and I'll be your trainer today for this e-learning personal license course from Get Licensed. Today on this course we'll be covering a number of different subjects, including personal licenses themselves, premises licenses, the law, temporary event notices, and everything else you need to know in order to take your exam to get your personal license. Introduction. So the Licensing Act of 2003 came into force in November 2005. This is the act that all the work we do on licensed premises is covered. Okay, so previously we used to work under an older act, which is the 1964 Act. This act was a complete rewrite of that and covered major changes in the retail sale of alcohol, late night entertainment, as well as sale of hot food and drink after 11 p.m. We're also going to go through a few other bits. We're going to talk about personal licenses. So personal license is actually what you're doing right now. You're doing a course now, which is going to give you the information you need to pass an exam. Once you've passed that exam, you then have to apply to the local authority where you live, and they will grant you a personal license. We'll go into a lot more detail on that a little bit later on the course. For now, all you need to know is the personal license is a little bit like a driving license. You'll get a card, and that license will be kept with you whenever you're working on licensed premises. We'll also discuss licensed premises themselves, how to apply for a premises license, what the law says about the operating hours of the premises license, and all the conditions that you have to adhere to once you do have a premises license. We'll also discuss temporary event notices. So temporary event notices is one of two options. It can either be an event that's held completely off a licensed premises, such as in a park or something like that, or it might be an event that's held on the licensed premises but is actually not standardized with the normal standard operating conditions that that license works under. For example, if you wanted to stay open an hour after your designated closing time, you may need to apply for a temporary event notice in order to be granted that option by the council. We also will very briefly touch on club premises certificates. Club premises certificates is not something that is very widely known to a lot of people. It's basically talking about things like private members clubs. Now, we're not talking about private members clubs like very rich people going to stay in a private members club and spend a lot of money. Those type of premises actually normally will have a full premises license because they're all about profit. A club premises certificate is normally actually referring to a hockey club, rugby club, football club, where they've got a small area set aside for members and their guests to have a few drinks after a game. Also, some British Legion places are covered under the club premises certificate as well. There's quite a few rules involved with this, involving a club premises. In order to get granted it, for example, you cannot operate for a profit. So there can be no money changing hands for profit. It can cover cost, but that's all. Essentially, there's no premises license required for that. And also there's a lot of other rules that are not required for a club premises certificate, all of which we'll go into a little bit more detail later. Licensing objectives. Okay, so there are 4 licensing objectives that have been set out by the Licensing Act of 2003. Okay, so this means whenever a premises wants to open, they have to show the council how are they going to promote these 4 licensing objectives. So the licensing objectives are prevention of crime and disorder, prevention of public nuisance, public safety, and protection of children from harm. Whenever you're looking to open a premises, you would have to show the council how you're going to promote those 4 licensing objectives. Each of those objectives is of equal importance, and each of those has to be clearly shown when you do your application for a premises license as to how are you going to promote these and make sure that these objectives are followed. Under the Act, there's also 4 recognized licensable activities. These licensable activities cover mainly the first one, which is retail sale of alcohol. So retail sale of alcohol simply means it's a sale of alcohol to the end user, the person who is going to consume it. Okay, so if I'm selling to you and you're going to drink the alcohol, you are the end user, and therefore the sale comes under retail. So that is retail sale of alcohol. Next up, we have supply of alcohol on club premises. Remember, that's the one we just discussed earlier, where we said there is no premises license required for that because the owners of the alcohol are actually the members of the club already. So that's called supply of alcohol on a club premises. Then we have quite a large one. This one covers quite a wide variety of subjects, and this is called regulated entertainment. Now, this covers everything from indoor sporting, large-scale sporting events, outdoor sporting events, live music and dancing. Essentially, the one main point here is there has to be a profit included. If there's a profit included and a charge is being made with a view of making a profit, then this needs to go under regulated entertainment, which means the council have got certain authority over there. And you do have to get clearance from the council in order to run certain events. Lastly, we have late night refreshment. Late night refreshment is a new one brought in through the new act, which covers any sale of hot food or drink between 11 p.m. and 5 a.m. Essentially, what it's saying is if you are going to serve hot food and drink between those hours, the council regulates it, which means they might tell you you need security on your premises, or they might just say you're not allowed to open at all. Now, this affects restaurants, curbside burger vans, as well as anywhere that's serving hot food or hot drinks between 11 p.m. and 5 a.m. The point of the act is that you're probably going to be serving people who are under the influence of alcohol. So if you're serving people under the influence of alcohol, you may then require certain protections against other members of the public who might be on your premises, as well as protection of your staff, public safety. So this is why the council now have the right to regulate that. Okay, let's go into a little bit more detail on what retail sale of alcohol actually is. So I know I covered it briefly a moment ago, but if we expand on that slightly and just talk about exactly what we mean. So as I said to you earlier, retail sale of alcohol simply means I'm selling to the end user, the person who's going to consume. There's really three types of licenses that are involved here. You either have an on license, which if you look around me in a pub like this is an on license premises, meaning that the alcohol will be consumed on the premises. If you think of a corner shop or Sainsbury's or Tesco's or any of the big shops, they have what is called an off license, which, as the name suggests, the consumption of the alcohol takes place off the premises. So no one can consume alcohol on the premises. They'd have to take the alcohol away and consume it off the premises. And lastly, you have something called an on-off license. And as the name suggests there, it means that you're actually licensed for people to drink on the premises as well as take away alcohol. Now, this might be in a restaurant where the restaurant allows you to take away a bottle of wine with a takeaway service, or maybe beer with a takeaway service, as well as obviously consume alcohol on the premises as well. Any premises where retail sales of alcohol take place must have somebody called a DPS. Now, a DPS is a designated premises supervisor. We will go into a lot more detail about them and their job in a little while, but essentially they are the single point of accountability. The buck stops with them. If anything goes wrong, any of the authorities will want to speak to the DPS or designated premises supervisor. Supply of alcohol on a club premises. As I also mentioned a little bit earlier, there is a club premises certificate, which is a licensed premises to a degree. Now, it's given a premises certificate. It's not given a full premises license. The rules involved with this would be that in order to get this, firstly, you're not operating for a profit. Secondly, there are clear club rules. There are also club members, and the venue is only open to members and their guests. You cannot have a club premises certificate which is open to the general public, because then it is not stipulated as a private members club only. Again, it's operating not for a profit. So this is more your hockey club, rugby club type scenario rather than a private members club in Mayfair, for example. Some examples of these could be sports clubs, working men's clubs, British Legion clubs, and things of that nature. As alcohol sales do not actually take place, there's no requirement for anyone to actually hold a personal license, and there's no requirement for a DPS to be in place either. All right, let's have a little look at regulated entertainment. So regulated entertainment is any sort of large-scale events, especially ones that go on possibly late into the night, with the view of making a profit. Quite often the charge is made. Now, this could include things like exhibition of films. This could be live music, dancing, anything like that for a large-scale audience, including things like late-night performances of a play with, let's say, in excess of a certain amount of people. We'll go into those numbers in a little bit. But that is regulated entertainment, and this is now covered under the Act as well. So the Licensing Act of 2003 does allow the authority, which is the local authority, the council, room to maneuver on this and actually stop performances from happening and give the go-ahead or the no-go-ahead on certain events as well. In the case of indoor sporting events, in order for it to fall under regulated entertainment, it needs to be, as I said, large scale. Large scale meaning that the number of spectators needs to be 1,000 people or greater. Also, any amplified music that is played late into the evening is also covered under regulated entertainment. If you have a licensed premises and you're going to have a band playing on your licensed premises, that actually has to be part of your premises license agreement with the council. It has to be on your conditions of your premises license. We'll go into details of that a little bit later, but just so you know, you can't decide if you've got a premises to have a live band playing on stage without getting the clearance from the council. And it really does need to be on your premises license in order to allow that to happen. If you do that without having it on your premises license, you are probably breaching the conditions of the agreed premises license. Some exemptions from live music might be that the music is being played between 8 a.m. and 11 p.m., so during what we call sociable hours, and the audience is no greater than 500 people. Also, unamplified music, meaning that there is no pickup on the guitars and there's no microphones involved, is also exempt. That means just small scale. So no one's going to be playing an acoustic guitar without a pickup or microphone to an audience of 10,000 people because no one will be able to hear them. So it would be a very small event in order for them to be able to play with people hearing them. Also, incidental music or background music is also exempt from being classed as regulated entertainment. As far as dancing is concerned, if the number of people involved is greater than 500 people, this would also be classed as regulated, as well as this dance happening between 11 p.m. and 5 a.m. If you're holding a number of events at the same location, it is up to the organizers to make sure that all the procedures are followed correctly for each section, and each individual section doesn't break through any numbers or any agreed conditions set about by the council. Entertainment at private events may also be licensable, but this is mainly if it's down to charging with a view of making a profit. I always say this to all my candidates: if you're ever in doubt and you're going to hold a private event, it is always best to speak to your local licensing authority and speak to the licensing officer there and make sure that you are not breaking any rules. If you break rules, it can be a very costly experience for you. Now let's talk a little bit about late night refreshment. Late night refreshment refers to the sale of any hot food or hot drink between the hours of 11 p.m. and 5 a.m. Once again, this is now classed as something that the council has authority over, and they can enforce things such as security on the door, CCTV being in place. They can also stop a place from being open serving hot food and drink. Just remember, it's only hot food and drink between the hours of 11 p.m. and 5 a.m. If you're going to serve cold drinks and cold sandwiches, for example, this would not fall under late night refreshment. Examples of places involved with this would be any takeaways, any curbside burger vans, some restaurants, as well as kebab shops. As long as no sales of alcohol are taking place, there will not be any requirement for any venue serving hot food and drink to have a DPS in place or to have a premises license. No one will need a personal license either, due to the fact that no sales of alcohol are actually taking place. Okay, so now we're going to talk about licensing authorities. So licensing authorities, you will probably think more of a local authority like your council, but actually the licensing authority we're referring to here is all of England and Wales. All of England and Wales counts as one licensing authority. However, it's broken down into the local boroughs and local councils. Okay, so when you're dealing with a licensing authority, you'll be dealing with them on a local level. So it'll be your local council, either where you live for a personal license, or if it's for a premises license, it'll be the council for where that premises is situated. A licensing full committee is made up of 10 to 15 members. Now, if they ever need to go through to a hearing process, which we'll talk about in a little bit, the licensing committee is broken into a subcommittee. There are 3 members of a licensing subcommittee, and they are directly dealing with any license applications that have had any objections raised. Now, this could be a premises license that's had objections raised by either the local residents or perhaps a statutory authority or the police, or it can be for a personal license application which has received an objection by the police. All licensing authorities will have a licensing department which will consist of any number of licensing officers. Now, the licensing officer directly deals with all the applications which do not receive any complaints or any objections by any authorities or anybody else. If there's no objections raised to either a personal license application or a premises license application, it'll be the licensing officer who will simply process this application. The licensing officer will also be the person that comes and carries out any inspections on licensed premises, as well as inspecting personal license holders and making sure that they have the correct personal license as well. The licensing authority is also required to keep a register of all license applications as well as license holders. This is a public document which is available for anybody on request and is quite often available online as well. Whenever a license application is contested to, either by a statutory authority, the police, or indeed people living in the area, in the case of a premises license, a hearing will be held. Now, the hearing is held by the 3 members of the licensing subcommittee. And this is the point where all parties get to put their points across in front of the licensing subcommittee. And there's a few options available here. It could be that the licensing subcommittee allow the people contesting to speak directly to the people who've put the application forward for the premises license. In this situation, this may be they reach an agreement amongst themselves, in which case the licensing subcommittee doesn't have to have any input. But most likely what will happen is the subcommittee will have to go away and make a decision. So they'll hear all sides of the parties' complaints, as well as the owners of the business who are putting forward their application that has received a objection. And in this situation, what they then have to do is go and decide what to do. In other words, do they grant the license as it was applied for? Or, more likely, do they grant the license with certain new conditions attached which take into consideration the complaints that have been raised? Or do they not grant the license at all? In other words, completely reject this. If the license is rejected, what happens is all parties have the right to appeal. In fact, no matter what the outcome is, all parties have the right to appeal. Any appeal needs to be made to the local magistrates within 21 days of the council's decision. Now, this is really a premises license we're talking about here. There's only one person that can object to a personal license application, and that is the licensing officer within the police. Okay, so if there's a criminal record and the licensing officer within the police feels that this is going to be a problem with that person's application going through, what will then have to happen is there will have to be a hearing. Once again, the police will then put forward their objections. The person in question has a chance to make a statement as well. And the licensing subcommittee then will make the decision as to whether to grant the personal license or indeed not grant it as requested by the police. Once again, as with any licensing hearing, all parties have the right to appeal to the local magistrates within 21 days of the outcome. One other reason for a licensing hearing may be in the situation where a venue that's already got a premises license has had a complaint raised against it. So it could be that the police have had to close it for disturbance. It could be that the local residents are complaining about noise or late night drinking that's happening outside the hours of the license. What happens in this situation is, once again, a hearing will be called for, and the process is exactly the same. So all parties will then attend the hearing, the licensing authority subcommittee will make a decision, and all parties then have the right within 21 days to appeal that decision with the local magistrates. All appeals can be made by anyone affected by any decision made by the licensing subcommittee. All appeals must be lodged in writing within 21 days of the decision being made. The licensing policy. The licensing policy is a document which is published every 5 years by the licensing authority. Okay, so licensing authority, being England and Wales, every 5 years they have to review their current policy and they have to issue a new one. The licensing policy will set about how the licensing authority will step forward to promote the licensing objectives. Just a reminder of the licensing objectives. They are public safety, prevention of crime and disorder, prevention of public nuisance, and protection of children from harm. So when the licensing authority comes forward with their policy, it needs to show how those 4 objectives will be promoted within the next 5 years. Any applicants applying for a premises license will need to review that document and see what special cases are involved in their application process. Other things included on this policy could be things such as saturation of business type in an area. What this means is the council say that there's no more licensed premises going to open on this street, for example, because of a saturation of these types of businesses in the area. Having read that, you wouldn't then go ahead and apply for a premises license on that street in that area because it would be rejected pretty quickly. When going about setting out their licensing policy, the authority also needs to look at the Licensing Act and the guidelines set out by the Secretary of State. Okay, so that's the end of that section. What you can do now is you can go down to the bottom and have a look at the mock test questions and see how you do. Feel free to rewatch any section where you're a little bit unsure of anything. And now let's head on to the next section. Okay, so the next section we're going to look at now is personal licenses. So a personal license is actually what you're doing this course for. So once you've completed this course, you'll be given a certificate, and that certificate will need to be sent to your local authority. When you send that certificate off to your local authority, you will also complete an application form, and you'll also have to get a DBS check, which is Disclosure Bar Services check. This is a criminal check, basically. Now, if you do have any kind of criminal record, it will be up to the police to decide whether to raise an objection or not. I'll go through the details of that later. For now, let's talk about a personal license itself. So first and foremost, you can only have one. So you apply for your personal license. Once you've got your personal license, that personal license is valid indefinitely, meaning that you won't have to renew it and it doesn't ever expire. Now, this is under current legislation. Of course, this may change in the future, but as it stands today, you have one license and it's valid indefinitely. A personal license can be granted to an individual even if that person isn't working on licensed premises. In order to apply for your personal license, you must be 18 or over. You must have a accreditation, so the certificate from doing this course, and you must not have had your license revoked by the local authority within the last 5 years. If any of those 3 are not met, your license application will be immediately rejected by the council. This would not go to a hearing, and there would be no appeals process for this because you're simply not meeting the criteria required in order to gain your personal license. The final check is not actually done by the licensing authority themselves. Although you apply and you send your application with a DBS certificate included, what will happen is if there is anything on your criminal record, the licensing officer will simply pass this to the chief licensing officer of the police in that area. The chief licensing officer of the police then has up to 14 days in order to raise an objection. If the chief licensing officer of the police does not raise an objection within 14 days, the licensing authority's licensing officer will simply continue with the application and eventually you will get your license granted. The application for a personal license. So this is made up of several parts. It's the application form itself. You'll need 2 photographs, one of which needs to be countersigned by somebody. Now, this person who signs your photograph needs to either be a professional, and there is a long list you can go through on the council's website of what they count as a professional, but there's a long list, and most professions are on that list. Or it could be a person of upstanding in the community, so it could be a pastor or a minister or somebody like that. All the person is doing when the person countersigns your photograph is saying that this photograph is a true likeness of you. So only one picture needs to be signed, and the other does not require a signature. The next thing that you are required to have is a basic disclosure. Now you can go online and you can apply for a basic disclosure. You can just type into a search engine basic disclosure or criminal record check. There'll be a number of companies that come up and you can simply go onto one and apply. It's anything from £25 to £40 is roughly how much it costs at the time of making this to get that done. It's important that you do have that done. A lot of councils will also have an expiry on that form as well. In other words, it will go stale after a certain amount of time. So you can't reuse an old one from 4 or 5 months ago. It has to be a new one issued normally within the last 1 to 3 months. That you would need to find out with your counsel yourself to find out exactly what time frame that they're willing to deal with. You'll also have to include your licensing fee, which again is at the time of making this anything between 30 and 40 pounds. I believe it's somewhere in the 35 pound range at the moment, and that's payable to your local authority. Upon applying for your license, you'll also have to declare any relevant offences. Now, a relevant offence or a foreign offence are offences that are either against the Licensing Act or certain criteria that have been laid out by the Licensing Act of 2003. A relevant offence just means that the offence was committed within England and Wales. A foreign offence means that the offence was committed outside of England and Wales. Now, if it was committed outside of England and Wales, even in Scotland or in Ireland, this is still classed as a foreign offence. But this needs to be declared upon your application. Things covered under these offences are any firearms type offences, drugs offences, certain violent offences, any offences under the Licensing Act of 1964, and some trading standards offences. Only unspent convictions will still appear on your criminal record check. It's important that during your application, no false statement is made to the licensing authority. This would be deemed as a criminal offence and could face you up to a fine of unlimited amounts, which could be imposed on you by a magistrate. Giving false information or false name or address details would count as giving false information. And remember, this is a criminal offence. As mentioned before, only the police have the right to object to a personal license application, providing that the applicant is over 18, holds the accredited qualification, and has not lost a personal license in the last 5 years. So it's only the police can object if those other 3 criteria are met. The police will only object if they feel the granting of the license will interfere with the prevention of crime and disorder objective of the law. Remember, if the police do raise an objection, the next stage would be you would go for a hearing in which the licensing subcommittee would hear both parties and then make a decision. If you're unhappy with the decision made, i.e. if your license is not granted, you have the right to appeal to the local magistrates within 21 days. Okay, so once you've got your license, you do have certain duties that you have to uphold. One of them is name changes or address changes. You have to inform the licensing authority where your license was initially issued. So it might have been a number of years ago. You have to inform them of any change of address and any change of name. Failure to inform the licensing authority of any name change or change of address could result in a level 2 fine. That's a £500 fine being issued to you. Duties and responsibilities of a personal license holder. First and foremost, you need to keep your personal license on you at all times when working. This is because the police or the licensing authority themselves may come and inspect. If they do this, they can ask to see your personal license. Now, failure to be able to comply with that request and failure to be able to produce this license can result in you getting a level 2 fine of £500. If you're ever charged with a relevant or foreign offence, it is your duty to inform the court upon your first appearance that you are a personal license holder. Once again, failure to do that would result in a potential level 2 £500 fine being issued to you. If convicted of any relevant or foreign offences, it is up to the court then to pass that information on to the licensing authority and let them know of any sentences that have been issued. A personal license holder would not be convicted for failing to provide the information to the council if they had reasonable excuse. It is up to the court to decide what is a reasonable excuse, though. So not knowing your obligations under the law does not follow a reasonable excuse. It's really down to the court not passing the information across to the licensing authority. That would be deemed as a reasonable excuse on your part if you believe the court was going to do that. Otherwise, it's always your responsibility as the personal license holder to make sure that the authority has had the information passed to them. One other thing to note is if you are caught drinking and driving or being under the influence in driving, so taking any other substances other than alcohol in driving, this may lead to a suspension of your personal license or in fact a full forfeiture of your license. So you could lose your personal license if you're convicted of drink driving. or driving under the influence. If a personal license holder is convicted of a relevant offense, the following could happen. Your personal license can be suspended for up to 6 months as a maximum. So the council can suspend a personal license for up to 6 months. Or alternatively, they can completely forfeit the license. In other words, you lose your license. Now, if that were to happen, you would have to wait 5 years in order to reapply for a personal license again. Okay, guys, so that brings us to the end of the section covering personal licenses. So if you go down and have a look at any mock questions that are on the page, go through those and see how you did. Once again, feel free to rewatch as many times as you need to get the information that you need. Let's go on to the next section now. So now we're going to be talking about premises licenses. So we've already spoken a little bit about it. What we're going to do now is I'm going to run through just a basic introduction of how would I apply for a new premises license. I'll go through that and then I'll go through some other details as well. Okay, so if we're looking at a premises license application, this means I am looking to license a premises in order to carry out licensable activities. Mainly, we're talking about retail sale of alcohol here. So let's concentrate on retail sale of alcohol. That's selling alcohol to the end user. So if I was going to open a pub like this, I would need to apply to the local authority for a premises license. Now, if we pretend that this venue here that I'm in today was a hole in the ground, so there was no venue to start. I'm not taking over from anywhere. I'm not starting a new business on an existing business. We're starting this as a brand new enterprise. So this is going to be a brand new business. In order for me to apply, I have to go through a few steps. First step is have a chat to the council and have a look at their licensing policy, because remember, that will show us if anything is saturated in the area. In other words, any business is saturated where we know we're going to have a hard time getting this license before we even start. The reason we do that first is because we want to make sure that we're not going to spend a lot of time and money when we're on a hiding to nothing. In other words, we're going to get rejected no matter what we do. So that's our first step. We check the licensing policy and we make sure that the venue is likely to get licensed. The next stage we need to do is we need to go ahead and we need to fill out a license application form. So we fill out the license application form. Part of the information on there will be how we're going to promote the 4 licensing objectives. In other words, how our business physically is going to promote those 4 licensing objectives. And we'll go through those in a little bit. We're going to also have to have a named DPS. So the person who is the designated premises supervisor, remember, the single point of accountability. So that person has to be named on that application as well. Once that's done, we also have to have a blueprint of the premises, as well as what is the premises about. So what is it? Is it a bar? Is it a nightclub? We literally have to tell the licensing authority exactly what our premises is about. At this stage, what happens, once we've submitted this formal application with all the bits and pieces included, what happens then is it goes into a standby situation. What happens is we have to advertise, which includes advertising on the building itself, at a reasonable eye level where people can read what our application is and the terms of our application, exactly what we want. So the hours of operation, what kind of business it is, how many staff we're going to have, how many people we're going to have on our premises, if we're going to have live music events, all of those things. It's got to be detailed with a link to the application itself on the building. We also have to advertise in the press in the local area as well. And what this does is this invites people living in the area to come forward and raise any objections. So if they come forward, they've got, normally it's about a month, 28 days, that this will stand and the council will do nothing with it. They'll just wait. After the time is up and no objections are raised by the locals in the area, there will also have to be statutory authorities who've also seen the application. Most applications today are electronic applications, meaning that you send one and then the council themselves will send it off to all the local statutory organizations that have an interest. This is things like police, health and safety, fire safety, all of those kind of bodies. Now, all of those bodies also have the right to raise an objection within that time frame, the 28 days or so time frame that the venue's been advertised for. So, few scenarios here. Scenario 1 is no one raises an objection. If no one has raised an objection, we will simply have our own self-imposed license conditions. So if I applied to open the venue till 1 a.m. and I was going to have a maximum occupancy of 600 people, and I was going to have security on a Friday night and Saturday night, and live music on a Friday night. Those were all in my application. The conditions will be becoming of that application. So I said I was going to close at 1 a.m. That is now a license condition. I have to close at 1 a.m. I can't decide I want to close at 2 a.m. one night because I've actually imposed that condition of 1 a.m. So this is the conditions that are self-imposed. Option 2 is that actually either your neighbors or a statutory authority or the police raise an objection to your application. And we kind of know where we're going to go with this because we've done this before. We've spoken about this. This is where you're going to end up going to a license hearing. So we're going back to our license hearing, our license subcommittee, who is going to be 3 members of the licensing full committee, which is 10 to 15 members. And we're going to go in front of that licensing subcommittee and we're going to have a discussion with them and anybody who's raised an objection. Once we've got through that stage, again, the licensing subcommittee will once again either rule in our favor. In other words, we get to actually open with the conditions that we self-imposed. More realistically, they're probably going to find a middle ground where they're going to come back to us and allow us to open our premises under the conditions that they set. So maybe reducing the closing time to midnight instead of 1 a.m. or increasing the number of security on a Friday or Saturday night or anything else that they decide to impose on us. Or option 3, completely reject the application, which is the worst case scenario for us. Again, as with all licensing hearings, whatever the outcome of the hearing is, all parties have the right to object and raise an appeal. So once they've gone through that process, it will then go through to the local magistrate in the area where the venue has put its application in. The last point of this application is with the magistrate. Whatever decision the magistrate makes will be the final decision and no further appeals can come from there. Now, a premises license can cover any premises that wants to sell alcohol that is brick and mortar, like the place you see around me here. But it doesn't only cover those. It can also cover movable structures such as burger vans, things like that. It can cover tents, fields for festivals, anything like that can be covered, as well as vessels that are like canal boats, things like that. They can still have a premises license, and that's still covered under the premises license. Once a premises license has been granted, it is granted indefinitely or until such time as the business goes bankrupt, the owner dies or becomes incapacitated and no one is put in the interim in charge of the business, or the license itself is surrendered back to the licensing authority. In other words, maybe my business didn't work out. I can't find a buyer for my business if I'm trying to sell it. So I decide to just close the business down completely and I simply surrender the license back to the licensing authority. Okay, so let's talk about who can apply for a premises license. Essentially, whoever applies for a premises license has to be over 18 years of age. However, it can also be applied for by a business. So it could be a brewery that applies for a premises license on behalf of that brewery. So a company or business can be the applicant for a premises license. As mentioned before, most sales of alcohol that we deal with are retail sales of alcohol. So sales of alcohol that are going to the consumer or end user. Any sales that are retail sales of alcohol will require a premises license as well as a DPS to be in place. The DPS must also hold a personal license. So to be a designated premises supervisor or DPS, you must hold a personal license. Okay, some examples now of places that actually do not require a premises license. So there's a few examples here where they don't require a premises license themselves. For example, if we talk about the brewery, if a brewery is simply supplying a pub chain with alcohol to sell, the brewery itself does not require a premises license because they're supplying a number of premises. Each premises that is supplied will require a premises license because that premises is supplying the retail user. So in other words, it is supplying the end user. Okay, but the actual business-to-business transactions do not require a premises license. This includes any cash and carry, any business-to-business wholesalers, Any business selling to a temporary event user as well, so someone who's formally applied for a temporary event notice, and they're called a premises user. And if I supply alcohol to a premises user, I, again, do not require any kind of license to do that as far as the Licensing Act of 2003 is concerned. As part of the license application for a premises, both the fire and the police service could carry out their own independent risk assessments as well and put forward recommendations. Responsible authorities, also known as statutory authorities, have the right to raise objections when it comes to a premises license application. So as mentioned before, there's quite a list of these guys that have the right to raise an objection to a license application. Just a few on that list include obviously fire, police, health and safety inspector, trading standards officers, local trading standards authority, planning officer, child protection unit, and primary care trust or local health board. Additional authorities may also be required if your premises license is going to be on a boat or vessel, for example. You may need British Waterways authorities as well to give you clearance for that. The council licensing policy will give you further information of who needs to be contacted in relating to a license application, and therefore who can raise objections to the application. So let's just go back momentarily to the appeals process and magistrate court actions following an appeal. So the first action the court could take is to dismiss the case entirely, which means the original decision still stands. So the council decision still stands. The second decision they could take is to amend the decision made by the council, making changes to whatever the council's decision was initially at the hearing. The magistrate court will also make an order for costs. They'll determine who will pay these costs and how much the court costs will be. Now let's talk a little bit about variations on the license. Now, what a variation means is if I was coming into this business now and I was going to take over the business. So I bought out the business and I wanted to run my own business from here, but I wanted to make some changes. If I wanted to make some changes, we would call that a variation. Now, there's two types of variation. There's a minor variation and a major variation. As the name suggests, a minor variation could be anything from very, very minor changes to the layout of the venue. It could be a change of DPS. In other words, putting somebody else's name down as a DPS. This would be a minor variation. Essentially, any variation you make that's not going to have an adverse effect on any of the license conditions or the licensing objectives. So if we look at a major variation briefly, that would change things like the operating hours. So in other words, what time we're closing the venue. Let's say we were open till 1. I've come in, bought the business, and I want to change now to being open till 3 in the morning. That would be classed as a major variation. Now, if I'm going to make a major variation, what I'd need to do is I would need to submit a full application through to the council. The only difference between this and just making a brand new application would be that I'd actually have to send a copy of the existing license through to the council as part of my application to make these major changes. As part of your application, the business will also have to put forward the business operating schedule. Now, essentially what this is, as I said, it's a description of the nature of the business, the hours of operation of the business, how you will enforce the licensing objectives at your venue, and how you promote those licensing objectives at your venue. In other words, for security and safety, you could have CCTV in operation. You could have SIA licensed door supervisors on certain nights, maybe busier nights of the week. You can have noise abatement rules. Now, noise abatement means that we want to find a way of getting our customers, when they leave our premises, to go away quietly and to leave the area quickly. Failure to do so can cause the neighbors to start to complain about noise. And if that happens, you can end up with licensing officers coming down, environmental health officers coming down, potentially you getting fines, you could get closed, and eventually your venue can go under review, which means you're going to end up having to go for a hearing and potentially have your license altered. So you don't want to have that. So you've got to have procedures in place to stop that from happening. One other aspect that you need to concentrate on is also looking after young people. So this would be protection of children from harm. Now, this aspect covers anything from refusing service to somebody who's underage, how to do your age checks, staff training, but also covers things like if you are a venue that has a restaurant attached to it and you are going to allow youngsters on the premises, how exactly are you going to do that safely? And what procedures have you got in place? What staff training do you have in place? in order to deal with young people on the premises. Looking at the 4 licensing objectives, let's have a look at them quickly individually and talk about each one and how we could actually go ahead and promote that licensing objective. So the first one is prevention of crime and disorder. Well, I've already said the best way for us to promote that licensing objective is to make sure we have things like CCTV cameras in operation, make sure we have SIA licensed door supervisors, we carry out safety checks, we have staff training in order to deal with antisocial behavior, how to decline service to a drunk person, etc., etc. So that's prevention of crime and disorder. Then we have public nuisance, as mentioned already. That could be just simply making sure that the crowd dissipates very quickly and we don't have any complaints of noise. It's not only noise that comes under public nuisance. The other thing that comes under public nuisance is smell as well. So if you have a restaurant and you have extractor fans, those extractor fans better have filters on them to get rid of any odors from the kitchen. So that'd be public nuisance. Protection of children from harm, I've already covered, but that just goes through making sure your staff trained, you're turning away people who are underage, you're doing proper ID checks as well. And lastly, we have public safety, which includes everything from your fire evacuation procedures, staff training in fire evacuations, your lighting, your outdoor lighting, any steps or anything like that. Do they have handrails up? All of those kind of things would be included in public safety. Partnership working. A number of different authorities work together in order to promote the safety of the general public and reduction of public nuisance in an area. So police, for example, looking at crime reduction. Environmental health are looking at things like noise and smell reduction. And trading standards are looking at ways to prevent harm to youngsters, including underage drinking in the area. Each licensed premises must comply with mandatory conditions. Now, these mandatory conditions are across the board for any licensed premises. So they're not specific to one particular license. They're specific to anyone with a premises license. The first condition is that a DPS must be in place. A designated premises supervisor must be in place at any licensed premises. This person does not have to be at the premises 24 hours a day, but they are responsible for the actions of staff at all times. So anything that happens, even when they're not at the premises, they're still responsible for. The next mandatory condition is that each sale must be made or authorized by a personal license holder. Now, if you're already working at a bar and you don't have a personal license, someone who has a personal license must have trained you in how to do your job. Any mistake that you make, they are accountable for. So if you serve somebody underage, it's still their personal license that is at risk for you doing that, because they're responsible for that sale of alcohol. If you're required to have security at your premises, the security has to be vetted by the Security Industry Authority, and they must be licensed by the SIA. All premises selling alcohol must have an age verification policy in place. Now, this includes Challenge 21 or Challenge 25. A preference to these days is the Challenge 25. Basically what that says, anybody looks younger than 25, we need staff to challenge them to make sure that they're over the age of 18 in order to purchase alcohol. Another mandatory condition is that no low-cost alcohol can be sold at a premises, and this is due to a legislative change that happened in May 2014. Another mandatory condition is that no irresponsible promotions can happen. Now, an irresponsible promotion is a little bit of a gray area because it's not really clearly defined. Essentially what we're saying is if I charged you £10 entrance and said you could drink anything you like for the first hour, this is encouraging people to overdrink very quickly and would be seen as irresponsible. Another very clear one is we cannot dispense alcohol directly into anybody's mouth from behind the bar. So, or even having anybody doing shots, we cannot have anyone pouring alcohol directly into somebody's mouth. This is, again, a mandatory condition. Another mandatory condition is that it has to be free water available for anybody who visits the premises as a customer. So free tap water has to be available for all customers. And lastly, drinks need to be available in small measures, and the measures have to be clear. So if you're ordering a glass of wine, instead of pouring a 250 milliliter glass, the member of staff needs to confirm whether they would like a small or large glass of wine. Small glass of wine should be 125 milliliters and a large glass is 250. Just pouring a large glass of wine without asking a customer could be in breach of trading standards regulations. Now, please remember this, that breach of any of those mandatory conditions could result in up to 6 months in prison or an unlimited fine. Now let's look at a review of a license. As mentioned before, if something's gone wrong, any member of the public or statutory authority has the right to call for a review of the premises. This is normally because a problem has happened. Maybe there was a fight. Maybe it was a failure of a test purchase. In other words, we sold alcohol to somebody under the age of 18. If this is the case, the review allows the council to reappraise the license and to look at any conditions that need to be changed. So again, it's literally like going through the premises license application all over again, and they're looking at areas that need to be tightened up. So maybe they'll decide you need more security on a certain night. Maybe they'll decide you can't handle the number of customers that you have as your maximum occupancy number. So maybe they'll reduce that number. As usual, with any hearing, the standard formula applies that anyone unhappy with the findings of the hearing can then appeal to the local magistrates within 21 days to contest that finding. Following the review of a premises, the council has the authority to suspend the premises license for up to 3 months. They could, of course, also revoke the license entirely, which means the venue can no longer operate, or they could add further conditions to that license. They may also decide to remove the designated premises supervisor. They may also decide not to close the premises, but to remove certain licensable activities from the premises. Any decision that the council make is fully appealable through the local appeals procedure with the magistrates court within 21 days. Display of the premises license. So on any premises, there has to be a public display of the license itself. This is a summary of the license. This is not the full license. The full premises license also has to be kept at the property on premises at all times. A summary needs to be up on display where any member of the public could read it, as well as any authority can read it as well. And that's a summary of all the conditions of that license. It'll also have the name of the DPS on there and any additional licensable conditions that have been attached as well. Failure to have a premises license on display can result in a fine of up to £500. That concludes the section on premises licenses and all the rules and conditions attached to that. If you go to the bottom and have a look at the mock exams, that should help you out with any questions that you may have. Anything you need to look over again, by all means, just go through the video again. The Designated Premises Supervisor, or DPS, is the single point of accountability who is named on the premises license. Okay, so when you go ahead with your premises license, you also have to put somebody's name down who is the designated premises supervisor. Now, not only do you have to put their name down, but that person also has to hold a personal license. So it can't be anybody, it has to be a personal license holder. Now, the only person who can object to the appointment of a DPS is the Chief Licensing Officer from the police. It is the DPS's responsibility to make sure all risk assessments are carried out, all staff training is done correctly, and any measures are put in place and enforced as part of their responsibilities. The DPS does not have to be on the premises at all times, but they're responsible for all the staff actions on the premises whilst it's in operation. They're also responsible for all risk assessments being put in place and all procedures being followed. Each venue can only have one DPS. That concludes the section on DPS. We're now moving on to the next section. The next section we're going to talk about is temporary event notices. A temporary event notice is either an event that is completely off licensed premises, in which case licensable activities are going to take place and an application needs to be made for these on a very temporary basis and a very short-term basis. Or it might be an event that's happening on a licensed premises, but it's under different conditions than the current license that's already in place. Either way, a temporary event notice needs to be made and the application has to go through to the council. The individual who makes the notification is known as a premises user. There are a number of limitations to a temporary event notice. Now, these limitations are put in place for a variety of reasons. One of them is the obvious: if you're going to hold a large number of temporary events at a licensed premises, the council will say very quickly, well, why don't you change your actual license to cover these types of events? So you can't hold more than 15 temporary event notices at the same premises within a single year. Also, the maximum number of people attending a temporary event notice is maxed out at 499. This includes staff. So if you had 20 staff working, that means you could have 479 customers invited for this temporary event notice. A temporary event notice can last anything from 24 hours up to 196 hours as a single event. However, there are again restrictions on this because the maximum number of days that you can have in total is 21. So you couldn't have a 7-day event that you have 15 times because that would go over your allowance of 21 days. So your maximum amount of time for an event might be 7 days, but your maximum amount of days per year is 21. So if you were going to have 7-day events, you could only have 3 of those in a calendar year before you run out of days. Again, these are little backstops that are put in by the licensing authority to stop people abusing the process itself. There must also be a minimum of 24 hours break between events as well. You couldn't have one event that finishes tonight and then a next event that starts within a few hours of that. There has to be a 24-hour gap between events. A personal license holder is somebody who holds a personal license, and that person can have up to 50, that's 50, temporary events per year. However, they're still restricted if they're going to have those events all on the same premises. Remember, you can only have 15 at the same premises per year. But as a personal license holder, if you're holding events all over the place, you can have up to 50 of those per year. A non-personal license holder can have up to 5 temporary events per year. A late temporary event notice is where you're applying under 10 days, but over 5 days before the event's due to take place. Now, a personal license holder can have up to 10 late 10s per calendar year, as a non-personal license holder can have 2 temporary event notices that are late per calendar year. So that is less than 10 days before the start of the event, but over 5 days. So if it's less than 5 days, you would not be able to put a successful application through for a temporary event notice. A temporary events notice application is made via the council and is normally done electronically. If it's done electronically, the council will then send the form off to the police as well as the environmental health officers. It's up to either of those to raise an objection, and any objections raised would lead to us going to a hearing, in which case the raised objections would be heard and a decision would be taken by the licensing subcommittee on whether the temporary event notice would go ahead or not. So once again, it's either the police or environmental health who can object to a temporary event notice. A late temporary event notice is simply an event notice that is listed less than 10 days before the start of the event. There are provisions for late temporary event notices, as I said to you before. There are 10 for a personal license holder and 2 for a non-personal license holder. It is the premises user who has a duty to make sure that they have a copy of their temporary event notice on display, as well as available for any members of either the licensing authority, police department, or environmental health who may request to see it. Failure to have a temporary event notice on display can lead to you having a fine of up to £500. That's a level 2 fine of £500. And that concludes our section on temporary event notices. Feel free to watch it again if there's anything you're unsure about, and then go down to the bottom and have a look at the questions. The next section we're going to look at is protection of children from harm. As most people know, it's illegal to sell alcohol to anybody under the age of 18. You might have heard of Challenge 25. Now, this doesn't necessarily mean the person has to be 25. Essentially, what it's saying is if somebody looks younger than 25, the staff should challenge to make sure that they're over 18. If you fail to challenge, you may be serving to somebody under the age of 18, which could result in a £90 spot fine for the person who's done the serving. Plus, it could result in a much greater fine for the premises, as well as potentially putting the premises license at risk, so potentially risking everybody's job inside the premises. Also, what we need to understand is what can we accept as ID. So the first thing to remember is ID needs to be photographic. There's no good in me accepting somebody's birth certificate because there's no way I can possibly know who that person is. So photographic IDs that we will accept would be anything from a driver's license, any country, doesn't matter, as long as you believe it's a genuine license. A passport, again, any country, doesn't matter. Or a proof of age standard scheme card or pass card, which has a pass hologram logo on it. Some venues are not overly happy about accepting those, and it is down to the premises itself as to which IDs they will accept and won't accept.
Hi.
Hello.
Can I get a beer, please?
Yeah, you can, but could I see some ID first?
Oh, I don't have it with me, but I'm 19.
Yeah?
Yeah.
I'm afraid without the ID I can't serve.
Really? Oh, okay, thank you. Have a good night. Damn.
Not all people who are under the age of 18 may look so obvious. This is why we have the Challenge 25 rule in place, just to make staff's lives a little bit easier when it comes to checking ID. Now, when we do check an ID, it is important that we actually physically check the ID. So things to look for would be checking their date of birth. However, they probably memorize the date of birth for the ID. What you could do is throw in a curveball question, asking them something like first line of the address, or possibly a postcode, or maybe their star sign. Any of these could help you determine whether this person is genuine or if perhaps this is not their ID. Not all fake IDs are actually fakes. Quite often there will be a brother, sister, cousin who they borrowed their ID and they're using that to purchase. So don't look necessarily for something to be fake as such.
Hey.
Hey.
How you doing?
I'm good. How you doing?
Good.
Good.
Could I get a kernel, please?
Yeah, of course you can. Can I see some ID?
Oh, yeah, sure. 1 sec. There you go.
Perfect. Amanda Mensah. When were you born?
June 4th, 1989.
89, perfect. It says the 3rd of August 1995 on this
Yeah.
one.
Oh, I get that mixed up
Yeah?
all the time. Yeah.
I'm afraid I can't accept it.
Are you serious?
Yeah, it looks very fake.
This is me.
Yeah, you didn't know what your birthday was.
Whatever. Like, I'm done. Whatever.
Okay, so the main thing we're looking at here is underage children on a licensed premises. It's an offense to sell alcohol to anybody under the age of 18. It's also an offense to allow the sale to take place or to allow anyone to purchase alcohol on behalf of somebody under the age of 18, unless certain conditions are met, which we'll go through in a little bit. It's also an offense to buy or attempt to buy alcohol for somebody under the age of 18. This is called a proxy sale, and anyone doing that is committing a criminal offense. This would be somebody going into a corner shop and buying alcohol for a 15 or 16-year-old outside that corner shop, where the owner of the shop doesn't realize that the sale is not taking place for this person, but this person is going to go out and give the alcohol to the people outside. If you could prove that you didn't know, as the owner of the shop, you didn't know that this was happening, you have not committed an offense. It is the person who's come in to purchase alcohol on behalf of the people underage that's committed the full offense. The maximum fine for allowing this to happen is a level 5 unlimited fine. There is one exception to the consumption of alcohol on licensed premises by somebody under the age of 18. So the exemption is the person must be of 16 or 17 years of age. They can only have one drink, which is beer, wine, or cider. The drink needs to be with a table meal, and the drink needs to have been purchased by a responsible adult over the age of 18. Now, what is a responsible adult? Well, that would be your decision as a person working behind the bar, potentially, who has to decide whether this person is responsible. So somebody whose friend is 18 and they're 16, we would likely say that that is not a responsible adult. Responsible adult is more referring to somebody like a parent or guardian rather than a friend who's just a few years older than them. Remember, this exception is for a consumption only. They can only have one drink, and the drink needs to be purchased by somebody who's responsible and over the age of 18. The under 18 person can never purchase alcohol directly. Persistent underage sales. Premises license holder who's caught selling alcohol to an under 18-year-old twice in a 3-month consecutive period could face the following: an unlimited fine or a suspension or forfeiture of the premises license. As an alternative to prosecution, the venue itself may agree to close from 48 hours to 2 weeks with the agreement of the police. It's also an offense for an adult to send an under 18-year-old to collect alcohol that has been purchased online or over the telephone. It's also an offense to deliver alcohol to an under 18-year-old or to allow the delivery to take place. However, no offense has been committed if the under 18-year-old accepts a delivery of alcohol at their home or if they're on work premises doing shadowing or work experience. Now let's talk about allowing an under 18-year-old behind the bar. So if we have an under 18-year-old working on the premises, they can work legally from 16 or 17-year-old in certain roles. Now these would be things like bottle collection or perhaps table meal services. However, to work behind the bar, the person must be 18 years old. However, we can allow an under 18-year-old to work behind a bar as long as each and every sale has been authorized by a personal license holder. Okay, so that would mean you'd actually have to stand next to them and authorize every single sale that went through. Failure to do so would be a breach of the law. If an under 18-year-old is working at a premises where alcohol is being served with a table meal, this is perfectly legal and they're allowed to work as part of a table service, waiter or waitress, serving alcohol as part of that service. All right, let's talk about children on licensed premises. Now, we refer to children being under the age of 18, but specifically in this case, we're going to talk about under the age of 16. So it's illegal to allow an under 16-year-old on licensed premises who is unaccompanied. It's also illegal to allow an unaccompanied child under the age of 16 on licensed premises between the hours of midnight and 5 a.m. It's up to the license holder to determine whether children will be allowed on the premises, and if so, in what situations they would be allowed, and of course making sure the staff are trained to deal with children on licensed premises. This also needs to be clearly covered in the venue's operating schedule. Now, when we talk about youngsters on licensed premises, what we need to always think about is checking ID. So ID checks is very, very important, and trading standards would make sure that you do your ID checks correctly. So when we check an ID, what we're looking for is photographic ID only. We're looking at photographic ID, something along the lines of either a driver's license, EU pass ID with a photograph as well as a date of birth on it, or of course a passport. There is of course a proof of age standard scheme card which can be used as well, which is a UK government mandated card, which is a proof of age standard scheme hologram logo which needs to be on the card itself. So we need to make sure we make eye contact. We need to ask them questions, anything from what's your star sign, line of an address, anything like that that they may not have memorized that we can see maybe on a driver's license, which could trip them up if they are in fact lying. Don't forget, a fake ID doesn't necessarily mean that it's fake. It might be borrowed from a friend, cousin, sister, or brother. So they may actually have some of that information, but as soon as you start asking questions, they may start to get a little bit tripped up. If they are not answering the questions to your satisfaction, always refuse service. Test purchasing. Test purchasing could be held by either the council, the police, or trading standards. These days, it's primarily run in partnership with all three agencies, but led by trading standards. Customer test purchase. This happens when the local authority, normally in partnership with trading standards and the police, may send underage people into your premises to try and buy alcohol. When they do this, the person will come to the bar and ask for a drink. If that person is then served, you've broken the law. In order to catch you, what will normally happen is there will be some undercover officers in the area who are watching and witnessing the actual transaction take place, and you can then be fined £90 as the bar server. So in other words, whoever's behind the bar that makes the sale will be fined £90. The premises itself will also face further fines, plus the license of the premises is now put at risk as well.
Hello.
Hi.
Hi.
Do you serve the Colonel here?
The Colonel, yes, I've got the Colonel. Here we go. £10.
Okay.
Thank you. Here's your seat. Have a good night.
Thank you.
Sorry, fella.
I noticed you just served the young lady over there and you didn't ask for any ID.
I mean, she looks about 19, 20, yeah?
Bad news for you, my friend. Trading standards officers, this was a test purchase.
It's a £90 charge. You've got 21 days to contest it in the magistrate's court.
I'm sure she's 19, though.
Unfortunately, my friend, she's 17, she came with us. I'm going to have to speak to your manager as well. Remember guys, if you follow all the rules and procedures, passing a test purchase should be no problem at all.
Hello.
Hi. Do you serve the Colonel here?
We do, but could I see some ID?
Oh, I don't have it with me.
No?
No.
I have to insist though. I need to see some ID. I can't serve you alcohol without seeing some ID.
Okay, so I'm actually 17 and this was a test purchase. And you passed.
I did.
Yeah.
Cool.
I'll be on my way.
Very good. Have
Thank
a good
you.
night.
Now, what test purchasing does is they'll send an underage person into a bar area or perhaps a shop to purchase alcohol and test your response. So the test is, will you just serve the person without asking for ID, or will you ask for ID and refuse service? If you refuse service, you've won. You've basically passed the test purchase. As soon as you served alcohol to the underage person, you failed the test purchase. Now, this could end in two ways. One way would be a £90 spot fine for the person who served the alcohol. So if you serve the alcohol, you get a £90 fine against you. But also the venue itself then can go under review, and they could face a £5,000 fine per conviction of a sale underage as well. It's good practice for all premises to make sure that all staff are trained in age verification policies, and that you do have age verification policies on display as well. Age verification policies cover things like Challenge 21 or Challenge 25. As I said much earlier, the Challenge 25 policy is the one that is now really, strictly speaking, the one that we use. Essentially, all we're saying is if the customer looks younger than 25, we're going to ask for ID to make sure that they're over 18. Other age-restricted products that the trading standards officers might look at, and of course this would be happening maybe outside of a pub-club environment, more in a shop environment. This could be anything from fireworks, which requires an 18-year-old person to purchase, knives and shops, 18 again, solvents, which is 18, lottery tickets is 16 years old, spray paints is 16 years old, cigarettes is 18 years old. It was 16 before, but now in the last few years it's become 18 to purchase. And any games or videos that are age limited are also quite often test purchased by trading standards officers inside shops as well. So if they're selling a game that's got an 18 age restriction to a person who's obviously underage, which trading standards would be sending to purchase, then what will happen is obviously, again, the same spot fine procedure will happen. So it'll be a £90 spot fine to the person making the sale. We do have something called due diligence defense. Due diligence defense is really a one-off defense that can be used in a situation where you've made a mistake and sold alcohol to somebody underage. It's not something that you can go back to and use every time. It's a kind of thing that'll get you off one time only, and that's only if the licensing authority determines that you do have a defense. Now, the defense could be anything from you're relying on actions of somebody else. No one believed the person was underage. This is something you'll find with a test purchase they'll never do. They will never send somebody in for a test purchase who is clearly looking like really old. So in other words, looking maybe 6'2" in height, and they've got a full facial hair if they're a guy or anything like that. It's unlikely the trading standards officers would ever send anyone looking like that in. Because if they did that, you could have a due diligence defense if you served them by saying no one believed this person was underage. However, what they'll normally do is they'll send somebody in who looks their age. They'll send a 15-year-old person in who looks like they're 15 and then test your reaction to it. It'll be for the courts to decide whether a due diligence will stand up or not. And if you do have reasonable excuse, it'll be for the courts to decide what is reasonable. Having evidence of staff training and due diligence is very important in a defense against an underage sale. So having a refusal book or anything that you can use as evidence is very important in these cases. It's the kind of thing that no one ever wants to have until you need it, then suddenly you wish you did have it. A refusals book is simply a book that says who refused the sale and on what grounds they did and what time and date they did that on. So it's very straightforward, very simple, but can be used as good evidence in the defense of underage sales. So that concludes our section on protection of children. So we're now moving on to the next section. Please look at the bottom for any questions that come up that may help you and rewatch anything you need to watch again. This section is all about legal rights and duties whilst working on licensed premises. First duty we have is the duty to prevent disorderly conduct on licensed premises. Essentially, we cannot allow disorderly conduct to take place, and we have to stop it. Now, this might be in a situation where we need to call security, and security needs to remove people from the premises, or refuse sales, or physically remove people from the premises ourselves. Essentially, we cannot allow people to break the law on our premises. If we allow this to happen, this can put our premises license at risk. It is the responsibility of all persons working on a licensed premises, whether paid or unpaid, to prevent disorderly conduct. As part of that, we all have a duty to refuse to serve a drunk. It's illegal to serve somebody on a licensed premises who is drunk. We cannot do this, it's against the law. So what we need to do is we need to look for subjective signs that somebody is drunk. These could be anything from how they're walking, how they're talking, are they able to keep their head up and make a conversation with you and keep eye contact. If they can't do this, you should always refuse the service. If you do refuse the service, remember to always depersonalize this. For example, saying it is against the law for me to serve somebody.
Hello, mate.
Right, mate.
Another beer, please, barman.
Another beer?
Yeah.
Yeah, so look, you look like you had enough for
I
tonight.
think you've had too much.
You had way too much fun tonight.
Have had way too much fun tonight.
I did, so much so that I'm not going to get a 90 quid fine.
You're not going to, neither am I. Can I have a beer, please?
I'm not going to lose my license.
I will not lose your license.
The venue's going to get fined, so I'll rather not.
Come on, one more beer, mate.
Nothing personal, mate, but it's not
One more beer.
not going to happen, mate.
One beer.
Not going to happen. I'll get you a taxi. How about I get you a taxi?
What was that cocktail?
Now, when we talk about a drunk person, we're talking about a subjective analysis of their behavior. What I mean by that is we're looking at a measure which we're actually using our opinion to formulate. So when we're looking at a drunk person, we're simply looking at, can they make eye contact with us? Can they hold their head up? Are they slurring their words? Are they in a state where we don't think they should have any more alcohol? It's subjective because we're not measuring it against anything like an objective measure. So an objective measure for somebody's state of drunkenness would be either a breathalyzer or blood sample. We, working behind a bar, do not have those pieces of equipment available. So we simply are going to base it on their behavior. And we have a duty to refuse service to a drunk. If we serve a drunk person, we're back in the same position before where we get a £90 spot fine for serving a drunk person. So remember, if you serve a drunk person, you can get fined £90 for that service. A police officer in uniform can issue the fine for £90. If convicted through the courts, you can face a level 3 fine of up to £1,000 for serving somebody who's drunk. Failure to leave a licensed premises. Now, if I asked you to leave a licensed premises and you fail to leave, you're breaking the law. Also, what we need to focus on is if somebody refuses to leave. So if somebody refuses to leave a premises because they're acting in an inappropriate way. Now, this could be anything from not following the house rules, maybe insulting staff, becoming aggressive, a bit too rowdy, upsetting other members of the public. It's time for them to leave the premises. Now, obviously, initially what we want to do is we just want to ask them nicely to leave. In a perfect world, they would pack up their stuff and they would walk out the door at this point. Unfortunately, a lot of the time they may refuse to do this. Legally, we cannot allow them to stay on a licensed premises. So what we will need to do is possibly call security in, and security would then use reasonable and necessary force to remove the person from the premises.
Thanks very much.
Welcome.
Mate, which way are you going?
Sorry, man. I'm really sorry. No, sorry, man. It's actually.
Fellas. It was an accident.
No, that wasn't an accident.
I didn't do anything.
Come on, you got a problem?
Sorry. No, man. I'm
You're
sorry.
outside.
Alright, listen, mate.
What? No, you need to calm down, mate. Don't tell me what to do. This is a public place. I'll do as I please.
Public place, but it's a private property.
Oh, do me a favour, mate. Come on, mate.
I'm really
You want
sorry.
some?
No, man, I don't.
Yeah.
Alright, listen,
yeah,
mate,
yeah.
mate, I need you to calm
Mate,
down.
stay out of this, mate.
Can you help me out
Listen,
here at all, man?
What?
It's a final warning, mate.
Yeah?
I'd rather not, man.
Come on.
Do we
Come on, bruv.
We don't need to do that.
Listen, mate.
There's no need.
Mate, I'll do you as well, son.
Yeah, listen.
Come on.
You need to
Come on,
go.
come on.
What?
Yeah.
What are you doing, mate? What are you doing, mate? I'll see you outside, mate.
So the Licensing Act 2003 states quite clearly that no one should remain on a licensed premises if they're asked to leave, and failure to comply with that request is a breach of that act. We can ask the police to assist us with removing somebody from the premises. However, if we have our own security who are employed, who are SIA licensed, Security Industry Authority licensed, we can ask them to use reasonable, necessary, and proportionate force to remove the person from the premises. Another thing that's very important to look at is irresponsible promotions. So irresponsible promotions would be me promoting the overconsumption of alcohol in a very short amount of time. So this could be anything from having posters up which showing massive consumption of alcohol to having deals where you can pay a small amount of money to drink an awful lot of alcohol in a very short amount of time. So encouraging the overconsumption of alcohol on a licensed premises is against the Licensing Act. So an irresponsible promotion, £10 entrance, all you can drink for 1 hour, would definitely imply that people need to drink as much as they can within that hour to get their money's worth. And this would then add to overconsumption of alcohol. Illegal drug activity. Obviously, it's illegal to allow drug activity to take place on a licensed premises. Illegal drugs on licensed premises are not acceptable in any situation. If you suspect illegal drugs are taking place at the venue, police should be called and the people should be removed from the venue immediately.
Right, mate, how you doing? All right?
Yeah, good, how you doing?
Yeah, mate, buzzing. Wicked atmosphere, innit? Proper vibes downstairs. DJ's playing some banging tunes.
You've got some powder on your nose, mate.
What?
You've got some white powder on your nose.
What's that?
Some white powder on your nose? You've been taking drugs?
No, mate, I've got a proper high-powered job in the city, mate. If anyone found out, I could get fired, do you know what I mean?
Yeah.
God forbid if my girlfriend or my family found out.
Look,
mate,
mate,
you're a lifesaver, absolute lifesaver, yeah.
I'm going to ask you to leave.
What?
I'm going to have to ask you to leave.
Why?
You've got white powder on your nose, your eyes are bloodshot, you're very
Hey,
erratic.
do me a favour, everyone does it round here, what's the big deal?
Yeah, well look, we've got a zero tolerance with drugs in this place. So
mate.
either you leave,
Yeah?
or I'll call the police.
You'll call the police?
I will.
Fine, mate. I'll leave then. Do you know why? Because it's rubbish here anyway.
Yeah, well you make your way downstairs.
Yeah, I am.
Cheers.
We need to show all the authorities that we're doing our utmost to stop this from happening. So we need to do things like toilet checks. We need to do searching potentially, depending on the risk assessment. And we need to also deal with people who potentially are dealing drugs on a licensed premises. This includes staff training on how to deal with it. The overwhelming decision really is whether to call the police or not. And this will come down to the decisions that have been made by the police in conjunction with the council and the authorities when we applied for our premises license. If the police have a zero tolerance policy and they will want to be request a call for any kind of number of minor drug offenses that may take place, then we would follow that procedure. The likelihood in today is that under a certain amount, we would simply deal with it in-house by banning the person and ejecting the person and potentially either flushing the drug waste or bagging, tagging and putting in a drop safe for the police to collect at a later time. For larger quantity dealer type scenarios, we would likely call the police to deal with it directly. Other ways that we can help to reduce the amount of drugs on our premises are things that are simple. Things like having the toilets manned at all times, having good lighting conditions, SIA security that are doing foot patrols at all times, carrying out searches on customers as they come into the premises, as well as doing premises searches themselves. Remember, police have the power to close a premises where they believe drug activity is taking place, and this could lead to a review of your premises, and eventually it could lead to the premises actually losing its premises license. Any personal license holder who is convicted of allowing illegal drug activity to take place can face a suspension of their personal license or forfeiture of their personal license. Anti-violence strategies. So the government has enforced many different anti-violence strategies that they could draw upon to try and reduce violence in and around the nighttime economy. This includes things like antisocial behavior orders, drink-free zones, alcohol reduction zones, and banning orders that they can place on people. It's always good practice that violence is dealt with quickly and efficiently by all premises with a license. This, of course, includes having licensed SIA door supervisors who can deal with problems before they escalate too far. So the idea here is to try and stop the situation from getting to the point of violence before it gets to that point. So a couple of things we could do to try and reduce violence is ensure good staff training, quick, efficient, safe, and friendly service by staff behind the bar. This includes just, making eye contact, greeting customers, even if you're dealing with another customer, just so that they don't get frustrated, because frustration is normally what can take people down the path towards violence. Also, running only responsible promotions is another good way of reducing the chances of violence taking hold. And lastly, making sure staff are trained to remain calm in violent situations. That concludes this section. As usual, you can go to the bottom and have a look at some mock questions, and then let's move on to the next section. In this section, we'll be looking at prohibitions and exemptions to licensable activities. Firstly, moving vehicles. It's illegal to sell alcohol from a moving vehicle at any time. However, sales can be made when the vehicle is parked either temporarily or permanently. Now let's look at premises that would be prohibited from selling alcohol at any time under any circumstances. So there's certain premises that would never be granted a premises license. Things like garages, which are serving vehicles and repairing vehicles, this would never be granted a premises license. Motorway service stations, this is a bit of a weird one because privately owned motorway service stations can apply for a license. However, they're more the exception than the rule. The rule is majority of motorway service stations will not be licensable. Any petrol stations serving mostly fuel is also never going to be granted a premises license. Don't confuse that with a petrol station that has a shop attached to it, like a Marks and Spencer's or Sainsbury's or something like that, because those then are selling produce from the store as well as fuel. And in fact, probably a lot more produce from the store in relation to the amount of fuel they sell. So they can apply for the license under those conditions. But a petrol station that's just got a little shop with maybe some milk and some chocolates and packets of crisps, that would not be granted a premises license. Now, in general, trains on a national voyage across the UK do not require a premises license to sell alcohol. However, the police can apply to a magistrate to put a court order to halt the sale of alcohol on trains between 2 points. Now, if you think about it, this would normally happen if you have trains going to Paddington from Reading, perhaps, because there's a football final on happening in Wembley, in London. And what they've done now is they've put a prohibition order in place from Reading, or perhaps even a station before Reading, all the way to Paddington, where the alcohol cannot be served onto the train. This is to reduce people getting drunk before they get to the venue itself, or to the game itself. And again, violence perhaps kicking up because of that. On the flip side to what we've just been talking about, we have venues that are completely exempt from having licenses and do not actually require a license to sell alcohol. The main one that we look at is one we just looked at now, which was the train. So the train itself does not require a license, neither does a hovercraft or an aircraft. They do not require premises licenses in order to serve alcohol. Also on board a boat or ferry on an international voyage, they do not require a license. However, a riverboat that has boat parties and so on, they would have a full premises license to operate. At an approved wharf or port, they do not require a premises license. This includes things like airside terminals at airports. Any premises occupied by the armed forces also do not require a premises license, as well as any premises exempt on the grounds of national security. That concludes that section. Please look at the bottom for any questions that may come up as part of your mock exams. We'll now move on to the next section. The next section we'll look at is powers and enforcement on licensed premises. The first thing we'll look at here is closure orders. Now, you can have a couple of different types of closure order. The first one we'll look at is all premises in an area. Now, this happens due to potentially, maybe again, going back to our football analogy earlier, maybe there's a game being played with an awful lot of people coming, and they want to keep the area safe for other people. So what they would do then is they would simply put a closure order for a number of hours for all licensed premises in that area. So not targeting one, but targeting all at the same time. This would encourage the crowd, both before the game and after the game, to move away. So before the game, they don't congregate in pubs, and potentially this is in the past historically led to violence. And the same thing after the game. It's ideal to get the crowd away and moving away and breaking up any large groups that you can have, which could potentially lead to violence. These closure orders can have a maximum time of up to 24 hours, and the police would apply to the magistrates to enforce these closure orders. A police officer with a rank of superintendent or above can apply to the magistrate to enforce this kind of closure order. Now we move on to closure orders targeted at a specific venue. Now this could be because there's trouble, noise complaints, perhaps a fight where the police want to close the venue. Now a police inspector or above can apply to a magistrate to put a closure order in place for a premises as a single premises only. And this would obviously not be good for the premises and most likely lead to a review of their current license, which would go through to the council as a hearing, as we've discussed earlier on in the course. A magistrate could also consider whether to enforce further conditions further than 24 hours after that period of closure is up. The magistrate would do this if they believed more disorder was likely to happen once the venue reopens. Closure orders and environmental health. Now, generally speaking, environmental health would issue a closure order purely for noise complaints. So this would be that there's been a lot of noise and there's been complaints. An environmental health officer who attends a scene then can issue up to a 24-hour closure notice on the venue. Failure to comply with a closure order could lead to a £20,000 fine or up to 3 months in prison. Rights of entry on licensed premises. As you probably are well aware, the police have the right to enter a premises if they believe crime is taking place at any time. Now, on a licensed premises, the police do not require a warrant to enter the premises. Failure to allow a police onto licensed premises could be seen as an obstruction of justice and is a criminal act. Other authorities also have the right to enter the licensed premises. Things like health and safety, fire, trading standards, all of these authorities, statutory authorities, have the right to enter our premises at any time to make sure that the venue is complying with the laws that they need to comply with. The police and licensing authorities have the right to investigate to make sure that the venue is operating within its license conditions. HM Revenue and Customs have the right to enter the premises and to confiscate anything that they believe has not got the correct levies and duties paid on it. If they're entering at night, they may come with the police, but once again, we would never refuse entry or assistance to any statutory authority. All right, that concludes that section. Have a look at the bottom, as usual. Go through any questions and rewatch anything that you haven't got clear in your own head. The next section we'll be looking at is unauthorized licensable activities. Licensable activity offenses. It's an offense to undertake any licensable activities without the correct license being in place. So this includes anything from operating the licensed premises outside of the conditions set. So in other words, we have a closing time of 1 a.m. and I'm still serving at 1:30. This would be a breach of the license condition. Offering things like music and dancing when that's not on our license. Operating at a completely unlicensed premises, which is obviously completely illegal. It's also an offense to knowingly allow unlicensed licensable activities to take place. The punishment for these offenses is an unlimited fine and or up to 6 months in prison. Once again, we look at a defense of this action, and the defense of due diligence comes back into play. So we can use a defense of due diligence if we are in a position where we can show it was a mistake, which was a genuine mistake, it was because of the actions of someone else, or I had no idea that this activity was taking place, or what happened was outside of my control. It must be shown, if I'm going to use a defense of due diligence, that all reasonable precautions were taken to prevent this from happening. Once again, it's for the courts to determine what is deemed as reasonable, and not knowing my obligations under the law, once again, is not deemed as a reasonable excuse. That concludes that section. Please look at the bottom for any mock questions, and let's move on to the next section. The next section is responsibilities in alcohol retailing. Let's look at the legal definition of what is alcohol. The legal definition of alcohol is any drink which has the alcohol by volume, or ABV, of greater than 0.5%. This is classed as alcoholic and would require a license to be sold. The strength of a drink is how much alcohol it contains. Now, the alcohol that we're talking about is ethanol, and it is always expressed as an ABV, or percentage volume. Now, most drinks such as beers will go anything from 3.5% all the way up to about 9%, depending on the strength. Wine, you can have anything from about 7% all the way up to 14 to 16%. And spirits, again, most spirits are in that area of about between 40 to 44%. There are exceptions to all of these, of course, as well. It's a requirement that packaged drinks with alcohol greater than 1.2% do show the percentage of alcohol by volume, so the customers know what they're buying. Another important definition is understanding what is classed as pure alcohol free. Alcohol free simply refers to anything with less than 0.05% of ABV. Low alcohol is no greater than 1.2%, and legally classed as alcoholic is anything greater than 0.5% ABV. A single unit of alcohol is also 8 grams maximum, or 10 milliliters. The effects of alcohol on the body. Now, alcohol is a drug, and drinking too much alcohol, the body can't process it quickly enough, and it starts to affect how our brain functions. Drinking more than 1 unit of alcohol per hour, the liver will not be able to process this, and we will start to become drunk. So the more we drink, with our body not able to process this, the more the ethanol builds up in the system. When drunk sensibly and in moderation, alcohol is not normally a problem for the body. But when drinking more than we're able to process, it can become a problem. Both the liver and the kidneys are affected, as well as our behavior. Blood alcohol concentration, or BAC, is a measure, an objective measure, where we can count how drunk somebody is. Now, this is normally done if somebody's had a car accident or something like that. And then there's an objective measure of how much alcohol is in somebody's system. Now, this is not subjective, this is completely objective. There's a measure as to how much ethanol is in their bloodstream. A BAC of 18 milligrams of alcohol in 100 milliliters of blood is the level above which it is an offense to drive. Most alcohol is processed through the liver. When you drink alcohol, it takes roughly 20 minutes for the alcohol to start to be processed by the liver and the BAC to start to fall. The liver processes 1 unit of alcohol per hour. Blood alcohol concentration can be affected by a number of things. Size and weight of the individual. Obviously, the bigger somebody is, the more blood they'll have. So the more alcohol they'll need to drink to reach the same blood alcohol concentration as somebody of smaller stature. Also, it's found that females have a higher blood alcohol concentration when compared to males who've drunk the same amount. Also, food eaten. If you've eaten food before you consume alcohol, this does line the stomach and reduces the speed at which alcohol is then absorbed into the bloodstream. Just quickly going to look at a couple of definitions here. So we've got binge drinking. Binge drinking is where people consume a large amount of alcohol over a short amount of time. So this is somebody who will not drink all week, but then on a Friday night, they'll drink a huge amounts of alcohol for Friday night and maybe Saturday night only, and then not drink again. Studies have shown that this still has a very negative effect on the body. In fact, it can have more of a negative effect than drinking less over a sustained period. The next one to look at is a chronic drinking. And chronic drinking means that somebody actually has a problem and they drink excessive amounts of alcohol on a sometimes daily basis. And this will have an effect on their liver's functionality, and other organs in the body as they're affected by the buildup of toxins. That concludes your personal license e-learning course with Get Licensed. Please watch this as many times as you can, as well as complete the mock exams until you get as close to 100% as possible. The actual exam will not require you to get 100%, but it would be good practice for you to get very close to that point in the mock exams. Thank you very much and good luck. Okay guys, now that you're done with your e-learning course, let's have a quick chat about the exam itself. Now the exam for personal license holders is 40 questions long and you have 1 hour to complete the exam. The questions are made up of all the material that we went through in the e-learning. The pass mark for the exam is 70%. So that requires you to get 28 out of 40 in order to pass this exam. There are also learning outcomes. Now, how the learning outcomes work is that you have to achieve at least one correct answer for every section. So each section is a learning outcome, and you have to achieve at least one correct answer for each learning outcome in order to pass. These exams are multiple choice with 4 potential options. There is only one correct option, and also please don't leave anything out. Okay guys, why don't you head over to the site now with Get Licensed and book your exam. This could be done either online through an e-learning exam, or it can be done at a premises for exam only.